Imagine a scenario where the boundaries of trust and legality converge, raising questions about parental responsibility and financial security. Can a bank account be opened in a child's name without their explicit permission? The intrigue deepens as we navigate the intricacies of financial guardianship and the implications for young individuals. In the labyrinth of personal finance, the concept of guardianship emerges as a cornerstone of responsibility. Guardians, often parents or legal custodians, wield the power to make decisions on behalf of minors, encompassing medical care, education, and indeed, financial matters. It is within this framework that the possibility of opening a bank account for a child without their direct consent becomes both plausible and contentious. The journey begins with the legal landscape, where regulations vary across jurisdictions. In many regions, the law grants parents the authority to act in the best interests of their children, including managing finances until the child reaches legal adulthood. This fundamental principle underpins the establishment of accounts in minors' names, ostensibly for their future benefit and financial literacy. Yet beneath the surface lies a nuanced debate over autonomy and parental prerogative. Should a child's consent be mandatory for such financial arrangements, or does parental authority suffice in safeguarding their interests? The ethical dimensions unfold as stakeholders weigh the rights of children against the responsibilities of guardians, evoking a discourse on informed consent and agency. Moreover, the practicalities of banking procedures add another layer of complexity to this narrative. Institutions bound by regulatory frameworks tread cautiously in facilitating accounts for minors, often mandating parental involvement to mitigate risks of misuse or misunderstanding. Here, the balance between accessibility and protection underscores the cautious approach taken by financial entities. Intriguingly, historical precedents and societal norms shape perspectives on parental stewardship and financial education. From early banking practices aimed at fostering fiscal awareness to modern initiatives promoting youth savings, the evolution reflects a continuum of attitudes towards financial inclusion and parental guidance. This evolution invites reflection on the evolving role of financial institutions in shaping future generations' fiscal acumen. Delving deeper into the ramifications, considerations extend beyond initial account setup to ongoing management and oversight. How are funds managed, and who retains authority over transactions and withdrawals? These pivotal questions underscore the dynamic interplay between parental responsibility and child empowerment in financial decision-making. Critically, the narrative extends beyond legal constructs to encompass psychological dimensions of trust and familial dynamics. How do children perceive financial autonomy? And to what extent does early exposure to banking shape their attitudes towards money management? The intersection of trust, transparency, and educational intent amplifies the stakes in fostering a generation of financially literate individuals. Equally compelling are the ethical dilemmas posed by scenarios of parental misuse or neglect of financial obligations. Instances where accounts are opened without genuine intent for the child's benefit raise ethical concerns about fiduciary duty and intergenerational equity. The moral imperative to act in a child's best interests resonates against a backdrop of evolving norms in parental accountability. As the narrative unfolds, divergent perspectives emerge, underscoring the multifaceted nature of the issue. Advocates of parental authority emphasize the need for practical solutions to safeguard children's financial futures, citing the complexities of modern family dynamics and economic exigencies. Conversely, proponents of child rights advocate for greater transparency and respect for minors' autonomy in financial matters. Amidst these debates, regulatory frameworks emerge as pivotal arbiters of policy and practice. How do legislative safeguards mitigate risks of exploitation or mismanagement in accounts opened on behalf of minors? The interplay between legal standards and ethical imperatives shapes institutional protocols, underscoring the imperative for compliance and accountability in financial governance. Furthermore, the global landscape reveals a mosaic of approaches towards youth financial empowerment, ranging from governmental initiatives to private sector collaborations. The emergence of digital banking solutions and educational programs underscores a paradigm shift towards inclusivity and proactive engagement in fostering financial resilience among the next generation. Compellingly, narratives of empowerment and vulnerability converge in stories of individuals navigating the complexities of early financial stewardship. From tales of prudent savings to cautionary tales of mismanagement, personal experiences underscore the transformative impact of early financial education and parental guidance. These narratives resonate as testaments to the enduring significance of financial literacy in shaping lifelong attitudes towards money. In conclusion, the question of opening a bank account in a child's name without their permission transcends legal stipulations to provoke reflections on ethics, autonomy, and parental responsibility. The journey through regulatory frameworks, ethical dilemmas, and societal norms underscores the imperative for balanced approaches to youth financial empowerment. Ultimately, the narrative invites stakeholders to navigate the nuances with empathy, foresight, and a commitment to shaping resilient financial futures for generations to come.